So are we live? We're not live with
Yes,
this
we are.
recording. Live. What is live? So next week we'll try and do this live. So at least we're recording. Okay. So let's start. So hello everyone. My name is Sagnik Mukherjee. I'm from the Calcuttan lawyers, and today what we are doing is we're trying to basically do a weekly roundup of all the important happenings in the legal industry that has happened in our country over the last 1 week. With me today, who we have Mr. Soham Dhara, who is not only my friend but also a colleague. He practices with me in the High Court at Calcutta. He specializes in the criminal side, but at the same time, he also does a very number of jobs that a practicing advocate often does. Um, so, just to give you a sense of what we are trying to do today, and then I'll introduce Shom a little more. Some of our viewers might have already noticed, and some of you who have not yet checked it out. Uh, from our Instagram handle and also on the Facebook handle, we have started a new series called the Calcuttan Lawyers Deal, through which we have been trying to bring you the one of the most remarkable news articles or happenings which has happened in the country in the legal industry on a given particular day, and we plan on to do one such video session or a live session. We'll see how it pans out every week on Saturdays. We couldn't do it on a Saturday because YouTube basically asked us to wait for 24 hours. So we're doing this on a Sunday. But from next week, we're going to do this on a Saturday, every Saturday, 10 a.m. So just to give you a little brief, a quick idea about who we're talking to. So who Shom really is. Not only is he practicing in the High Court at Calcutta, but uh, he has studied in he's done his graduation, which is he holds a BA LLB degree from the Calcutta University through Jogesh Chandra Chaudhary College, which is an accredited college by the Calcutta University. He's also been a very associated with the Rotaract brand for a long time. He has been an ardent member of Rotaract Club of Talibanj, and he's done a lot of philanthropic work. He has also written papers, and somehow legal research comes to him very naturally. I'll leave links to how to get in touch with him in the description below. You guys can get in touch with him through his Instagram handle or his Facebook link, or you can just shoot him an email if you want to collaborate or you want to get to know something. So what we are basically doing today, Shom, is we are rounding up everything that has happened over the last 1 week. And so, you want to say something as an opening statement or something to the viewers?
Well, it's obviously an honor because it's not every day you get to be a part of the TCL family. So thank you for that. Thank you for giving me an opportunity because other than that, if you guys don't know, TCL also hosts a podcast on Spotify and on number of platforms where eminent lawyers such as Sheila Dittoda and then our own SPC sir and number of other advocates, number of other legal luminaries have come. They have talked about their journeys and like what their outlook is about law. So thank you so much for incorporating me in that stream. Although this is not per se an incorporation, but I am incorporating myself in that line. So it is a forceful intrusion of sort, but
I don't
it's
I
always
don't
an
think
honor.
I don't think it's a forceful intrusion at all. I think you have been a very important part since day one. So all of that that's nonsense. Uh, because he brought up the TCL podcast. Season 2 is coming up next week. Uh, the first episode will probably have Mr. Tanuj Kalia, who is the founder of Law. We're still in conversation, so once that deal is finalized, we'll bring you the first episode. And also a special mention to Rishabh Khan and Jeet Brahma, both of two of our juniors who had actually come to the podcast and decided to do two episodes in the TCL podcast. So a shout out to them as well. So all right. So without wasting any further time of the viewers, so we have three things to discuss today. I believe,
Yes.
and I think we're going to start with there's a landmark judgment which was given by the Punjab and Haryana High Court regarding live-in relationships.
Yeah.
Yeah.
With regard to Punjab and Haryana High Court order, it's not a judgment per se, but it has an equally greater impact, which is on. Well, I'll just run through the entire factual matrix for now.
Mm-hmm.
On 21st May 2021, a couple approached the Honorable High Court seeking uh, protection from the girl's parents who were not so approving of their relationship. Now, coincidentally, they were in a live-in relationship.
Mm-hmm.
They were not married. The girl is a bit older, while the guy is just of 19 years. So they were waiting for the man to turn into
21.
21 so they can solemnize the marriage.
Right.
Now,
Right.
during that time, when the matter was being heard in the Honorable Punjab and Haryana High Court, uh, well, the High Court held that the right to choose one's own partner is also an important right which is enshrined under Article 21 of the Constitution of India, which is right to life. And it further stated that while granting protection to the couple, it further stated that it would be a travesty of justice in case protection is denied to a person who has opted to who have opted to reside together without the sanctity of marriage, and such persons to face dire consequences in the hands of persons from whom protection is sought for. Now, the interesting part about this is while the hearing was going on,
So
the
I'll just
learned.
before you go into the hearing part, let me just ask you a question from a very layman's point of view, because a lot of people might not because I for one, because I am already an advocate, I know certain things that a lot of people might not know or might not assume. So my question to you is that according to what the general established law is, a particular person, uh, when a or rather a guy and a girl, when they get married to each other, the legal age of marriage for the girl is 18 years old, and for the guy it is 21. So
21.
yeah, and so in this Punjab Haryana case, what we have in our hands is that we have a girl who is older than the guy, and
Yes.
the guy himself is 19, so he's not legally ready to get married. He's not
Married.
eligible to get married. Right. So do we also have similar laws on live-in relationships? Just out of your head, because
There,
my question, I'll just also tell you why I'm asking this question, because till one point of time, the what the legal system was is that it never even recognized live-in relationships in the country.
yes.
So marriage was the only way of a couple to stay together and then cohabit and do whatever. But now live-in relationships also, the Domestic Violence Act now covers it. Uh, as an example, because if I'm not wrong, if a man and a woman is now living in together, then if the woman is harmed in any way, then domestic violence also applies in those cases. So slowly recognition of that live-in relationship in the country has now increased. But doesn't that, I mean, how can a man and a woman who are not of the legal age of marriage even live in? Is there an embargo on that? It's just a
Well,
stupid question.
technically, no,
Hmm.
because in this case, both of them were adults. Okay, now the Indian Majority Act clearly states that if a person attains the age of majority, which in India is 18, then then he is allowed to do like anything he wants. Okay, but the embargo that a man has to be 21 and the woman has to be 18, that embargo, while it may sound like that it creates a barrier of sort with regard to the Indian Majority Act, but that embargo is particularly given by another statute altogether, another
What,
act
so
altogether.
what is the Indian Majority Act? I know what is the Indian
Indian
Majority Act is, but just for the
Indian Majority Act is an act which enshrines about the what how will I put it? It's actually a legal declaration of the fact that a person who attains the age of 18 is a major. Okay,
Acha,
he's
so
he
majority in that sense, so above 80.
yeah, yes. Okay, so
Yeah.
it is an official declaration of that.
Okay, okay,
Okay, so
okay.
now the thing is that there are other ways to, like, you can find like other avenues of that in Guardians and Wards Act. Okay, but exclusively it is the only act which deals with that. Now, as far as live-in relationships are concerned, as far as I know, to the best of my knowledge, there is not a single act which expressly deals with live-in relationships. What you told me about the fact that domestic violence act covers the live-in relationship, that that coverage is solely because of the distraught of the woman, in the sense
Correct.
the grievances of the woman. Okay, it
Correct.
is
When
an
where the
act.
woman is victimized.
Yes, the coverage was done solely to create a safeguard for them. But to
Mm.
objectively focus on the live-in relationship, unfortunately, till now, India has, I don't think India has any like specific act where the focus is of the live-in relationship primarily. Okay,
Correct.
so
Mm.
in that manner, what it does is, since already I have told you that Article 21 also gives a person the right to choose his or her own partner,
Mm-hmm.
and like on multiple occasions throughout various courts,
History.
the
Yeah, yeah.
same has been held.
Mm. Mm.
But the problem is, uh, like uh, like like I was about to say this right now, that when the hearing was going on, the learned AG of that Honorable High Court
So AG is
pleaded that
what is AG?
AG is Advocate General,
All right.
learned
Okay.
Advocate General, pleaded that one, society is still not like accepting of the live-in relationship concept, and
Mm-hmm.
two, on multiple occasions, the Punjab and Haryana High Court itself had not granted such orders in similar cases. So
Okay.
effectively, although Punjab and Haryana clearly stated that refusing such persons is a travesty of justice, but clearly the main issue is, whenever something comes with regard to these things, in the sense something which does not conform to any pre-existing societal ideas, we always sort of bring in this argument that society will not accept this. It's more or less like, to put it lightly, society is that disgruntled old uncle in an Indian marriage, where if they start playing Yo-Yo Honey Singh songs, he would demand ghazal. Okay, so that is the thing. Like, society for me has to change with the time, because time is not supposed to change with the
True,
society.
true. Of course.
So
Of course.
at the end of the day, like, society has to move on from being that Nanaji, and come to terms with the fact that there are new things that the new age people, that people belonging from different generations would want to execute, and it has to be accepting. I mean, it
Mm.
took us so long to get to abolish Section 377 of IPC with regard to unnatural sex. That is the thing, that in the sense that it took us so long, it should
Yeah.
be an it should it should be treated as an alarming sign more than a precedent, that things should not take so long to change for the better. So that is something I am glad about this order, because it upholds the rights of two people who actually want to
So
live in
the
together.
order has objectively said that if there are two people who have attained majority,
Hmm.
then the society cannot put an embargo on
Yes, yes. No one
how they're
can.
living. So yeah. So I think it's mane, can this be mane, acha, how do you define a landmark judgment? Mane, is this a landmark judgment? Does this constitute as a landmark judgment?
It's actually not. It's actually not. It is not a judgment altogether. It is an order.
It's an order. It's an order.
Landmark
Yeah.
judgment, to the best of my knowledge, is a judgment which sets out a new interpretation of an existing law,
New interpretation of an existing.
in a
All
way
right.
that, like, say for example, the judgment of K in Puttuswamy with regard to the Aadhaar card.
Hmm.
No other judgment has been
So
there.
what happened?
Right.
What just to ask you, just ekdam absolutely in brief, what happened in the Puttuswamy case?
Puttuswamy, in that case, it's actually a really long judgment. It is of, I
Just
guess,
just
600.
just just to touch upon it.
But it did two things. One, it overruled the judgment of ADM Jabalpur.
Okay.
Uh, yes, and second thing, it upheld the notion of right to privacy as an intrinsic part of Article 21, in the sense that actually it is actually a very ironical thing, because the judge who passed this judgment along with his colleagues, Mr. D.Y. Chandrachud,
Chandrachud.
Honorable Justice D.Y. Chandrachud, actually went on to overrule his father's judgment in the ADM Jabalpur case,
Okay.
which dealt with the emergency case as we all know it.
Okay.
So in that manner, yes, like that is a landmark judgment, judgment because it set out a new interpretation of an existing law. The fact
Right.
that Indian laws are very silent about right to privacy. Okay, there have been landmark judgments such as PUCL versus Union of India, but no one has ever clearly expressed the fact that no, right to privacy is also part of Article 21. So till now, it was silent, but now it is expressed. So that can come under that ambit.
Hmm. Acha, just to ask you, what is the difference between a judgment and an order?
Hmm?
What is the difference between,
Sorry.
like, I am asking this question because to me, when I'm going through or when I'm reading articles on the Punjab and Haryana order, this
Hmm.
particular order came from another order, right? So there was, um, am I wrong in saying this, or am I factually? I might be factually unaware
No,
of it.
factually, it did not. They had
But
they
the
filed a
case must have,
criminal writ petition,
it was a
and
writ
it was
petition.
taken up. Yes,
Okay, okay, all right, all right. Okay. So an order was passed. So
an order was passed.
right. So when a landmark judgment per se is actually given, for example, the Chandrachud judgment that you just cited, how is that? How are those judgments different from? Because this order to me, this order also is a very important order. I feel that it's a very important order in the perspective of progress as a society, as a country. I think this judgment stands as a very important thing. But how are those judgments rather different from orders like these? Just because
Uh,
this particular order is upholding something, is it just like
yes, mostly a landmark judgment. Uh, to me, like obviously that like there will be many viewers who will
of course.
disagree, many
Hmm.
viewers who actually have lot more experience than me, but the fact is that a landmark judgment is something which opens a new door for interpretation of an existing statute. Okay, and it has
Okay.
attained a finality. An order
That
is not
hmm.
a final thing. It can be, it is an, at best it can be called an intermediary thing. It uh,
For
that's
example,
why
the Kesavananda Bharti case, which stands as like the
hmm,
mother judgment
it
of
is a
all.
judgment.
So it's a judgment, and it's like it binds on so many things across the
Yes,
table,
absolutely.
right? All right.
An
So
order can be recalled by the same judge which has passed it. Okay,
hmm,
but in order for a judgment to be recalled, you have to challenge that, and it may not be taken up by. It is often the case that it isn't taken up by the same judge.
right, right. So this
So
when you're saying an order can be recalled, this word recall reminds me of something which is happening in Calcutta right now. We will come to that at the end of this discussion. I think we should touch upon it. Anyway, so yeah, so the Punjab and Haryana judgment. So that was one landmark thing for the week. So the
Hmm.
second thing I think which also happened, and we had also covered this in the Instagram, Instagram and Facebook pages. Links in the below, please follow. Is the ICSI Chartered Accountants matter?
ICAI actually. I'm sorry, I may have misplaced that. It's ICAI, Chartered
ICA, so
Accountant.
Chartered Accountant. Yeah, so I
Ah,
just
yes,
said
yes.
company secretary. So I'm sorry. So yeah. So what happened there?
This is a very bizarre case of vengeance, actually. So what happened was, uh, the name of the case is Risha Lodha versus ICI and another. If anybody wants to find the order, you can get that online. So it
Mm-hmm.
was taken up by the Honorable Rajasthan High Court. Now, what happened? The brief facts of it is that ICAI wanted to hold its intermediary examination from 21st November 2020 to 14th December 2020.
So what is the
Now,
ICA?
Institute of Chartered Accountant.
Also, this is their the- so these are the examinations which aspirants, the
Yes,
chartered
yes, yes.
accountant,
They
yeah,
have
they
three sets: foundation, intermediates, and the last step I actually
yeah,
forgot the
even I
name.
forgot some
So it's tough.
finals or something,
It's like one of the toughest exams in India, both
right?
CA exams and CS exams.
Mm,
So the thing is that they thought that it would be a nice time to hold the intermediate exams then.
mm,
So as the viewers will know, it is actually quite hard to like ignore that we are going through a pandemic from last year.
yeah, yeah.
So this person, Risha Lodha, this lady wrote an email. It was actually quite a stern email stating that if ICAI tries to hold the intermediate examination during those time in
Mm-hmm,
that period,
mm-hmm.
then the cases will rise and it will only hamper the students who are actually opting for that examination.
Sitting for those exams,
So,
right? Mm,
so she requested to postpone it until things get stabilized a bit.
mm.
So ICI did not take this suggestion kindly. So they sent her show cause notice, and on multiple occasions, this person apologized. Hello, am I audible?
Yeah, you're audible. I don't know for what reason my
Your camera
but
is stuck.
just give me a second. Let me see. What camera is not working? Just switch to the webcam. Yeah,
Hmm.
so we're gonna have to work with this. Yeah.
Okay, so what happened was that to an extent, the lady apologized on multiple forums.
Mm-hmm.
Okay, and on other and she has sent like apology letters to the president of ICAI and two other concerned persons as well. Yet, when the results were taken out, ICAI withheld her result.
Mm.
Okay, so what happened was that she went online to check her results, but she could not find that. Okay,
Okay. Okay.
and okay, you are back again.
Yeah. Yeah.
So she uh, could not find her result. She contacted the ICI, and somehow she got to know that her result had been withheld because of that one email which she had sent.
The email
Okay,
saying,
email saying that don't hold these examinations right now.
acha,
It
acha, acha,
is,
acha. Hmm.
yeah,
So
okay.
she
So
had basically
ICI,
protested to the, yeah.
yeah, so ICI took a strong view of this and they did that. So she approached the Rajasthan High Court. Rajasthan High Court was very displeased, to say the least, as it completely held the fact that every citizen can express their own views, and to take
Acha.
such a stern steps, especially when it is dealing with a person's future, it should not be like look at looked at
Looked at.
lightly.
Yeah. Yeah. Yep.
The Honorable High Court clearly stated that while the lady sent a very emotional mail, but still, even if it somehow touches upon the ego of the concerned person, even after that, such a strong step should not be taken. And subsequently, the court also went on to state that exemplary cost should be put on the ICAI, but it did not, and directed to declare her results.
Hmm.
So the entire fiasco happened because someone is expressing their own opinion.
And not only that, I think this is also a good judgment which reinstates the idea in the society or in the people that you can protest and no wrong should be done to you. You have
Yeah,
the right to
absolutely.
protest. You have the right to have your own opinion. So that's how the Indian democracy should work. Like I think, yeah,
Yeah, absolutely. So it's actually shocking that, in my honest opinion, setting aside the law completely, it's actually shocking that ICI even took this step. It's like they're in some school fights and like trying
yeah,
to.
yeah,
It's like they're running for some school captain election and like trying to sabotage the others' campaign.
yeah.
Such a
And when you
vengeful step.
compare, it is just an aspiring student in front of such a heavy and well-known
Yes,
institution. I don't think that's
exactly.
a fair fight.
The
Yeah.
odds are against the odds were against this lady, but the
Hmm.
fact that they should have like given their magnanimous stature, they should have had thought that maybe such a step would not be ideal,
But
especially when she had apologized on multiple forums.
that's where multiple number of times I think the judiciary has come to the rescue of the citizens, uh,
Yeah,
especially because
absolutely.
we have already talked about Justice Chandrachud. I think
Hmm.
Chandrachud, the performance of Chandrachud in the Supreme Court itself is such an example to it.
Yes. Example.
So
It is an example.
right, right. So we have already discussed two judgments which have basically spoken about curbing the rights of individuals in our country, and that is both of the times it has been done by two premier institutions, one being an educational institution, another being I'm guessing it was versus the state. So
Yes.
yeah, so that's interesting. All right, so the third topic, so we have three topics today. Third topic is section 97. There is a Supreme Court judgment.
Yes. About section 97 of
So
the
this is
CRPC.
97 of CRPC.
No, say.
Yeah, yeah, no,
You're
go ahead.
So the thing is that plenty of us often, in fact, prior to this judgment, I actually didn't know that there was this section. Plenty of people, advocates, and other aggrieved parties as well, go on knocking on the court's door whenever someone is illegally detained by way of a habeas corpus writ.
Correct.
Okay. Now,
So
habeas
what is the
corpus
habeas?
is a
So what
Latin
is the habeas corpus? Yeah, yeah. Yes.
habeas corpus is a Latin term which means literally to bring the body. If a person is illegally detained somewhere, mind you, illegally detained, not
Right, right,
detained by way of a criminal investigation.
right. So an
If
arrest is not an illegal detention.
yes, exactly,
Right, right.
illegally detained. After I guess after 2020, I think plenty of people may have forgotten this one factor that uh, detention based on a criminal investigation is not the same as being illegally detained. So the fact is that then if the court is if the court is of this opinion that yes, this person is illegally detained, then the court directs the state to bring the body. To bring the body means to bring the person in front of the court.
So,
Okay.
so basically meaning that that particular person, if he is illegally detained, should be released from his place of
Release.
detention
Yes,
and
exactly.
brought to the court. Right. Hmm.
Yes. And oh, and another thing, habeas corpus will not lie for missing persons cases. Okay, it is
Okay.
another thing which I guess Madras High Court held.
Okay.
So the fact is that the person who approached the court actually was aggrieved by the action of his in-laws, because his in-laws were illegally detaining his wife, so that cohabitation is not feasible.
All right.
O-
All right. So, in-laws are detaining a person's wife so that this person cannot cohabit with his wife.
yes, like in
So
the
they're,
sense
so they're
the
legally
girl and the,
married.
yes, the girl and the man got married. Okay, the lady's parents detained her. Okay,
Okay.
so that cohabitation is not feasible.
So,
So
does the case also tell you, do you know? I'm just asking this out of curiosity that in this particular matter, does the fact also say that there is the girl was was this marriage solemnized by the with the consent of both the parents? The parents.
no, no.
So that's the problem.
Yes, that is
It's
it.
like
In
it's
India,
like
a man and a
because
woman will
that's
never
exactly what
get.
I'm thinking. Like because if these two people are like of the legal age and
Yes,
they want to get married to each other, only in India, a society which follows Bollywood movies would only, only they are
yeah,
capable of restricting something like this,
yeah.
right?
In the sense that in India, a man and a woman will not get married; their families will.
Yes.
So
Ha, ha.
that is the thing.
If you're Manglik
Because
and non-Brahmin and all of that shit, then you don't get to
yes,
marry,
absolutely. Yes,
right?
absolutely. So the thing is that when so she got detained, okay, at her own home.
Mhm.
Now the question may arise: she was detained at her own home. What is so illegal about this? She
Hmm.
was not taken to some other place and caged. Okay, but the fact is that any detention, okay,
Without the
is
consent of that particular
like,
person,
yes, which is without the consent of the person is an illegal detention.
right?
Okay, and if the person is fit both mentally and physically, okay.
And also, if the
Now,
person is above the age of 18, I'm guessing, because otherwise, so most school students who are backbenchers would file habeas corpus every day.
yes, absolutely, yes. There are multiple factors,
This
yes,
also
but
this also somehow reminds me of our college gatekeeper.
yes, actually,
Right.
yeah, actually, the only, I believe, the only person who never used to get late.
Never ever. And you
I
always,
I, I think I think since you brought him up, I think you should like talk about like few of the anecdotes of this brilliant man's life actually, because
no, I will
people.
we will see because see we are going to meet every week, so we will have a lot of time to talk about all
Yeah,
of these things,
absolutely.
right? So and let us see what the college students who will actually watch this, what do acha, I'll ask this question to you that like all of you, whoever, like as if we have a lot of big audience or something, but we don't. So whoever is watching, so if you're still in college, so do you often feel like just the way he has explained how habeas corpus works? So you can, if you're above the age of 18 and you don't have consent to be somewhere, and if your college is detaining it, do you think that filing a habeas corpus might be a way out? Let us know. So yeah, section 97. So
So
let us just finish on
yeah,
that
yeah.
judgment.
So what happened was that first he approached the police authorities.
Hmm.
They didn't take any steps. So he approached the Supreme Court. Okay, the Honorable Supreme Court by way of a writ petition under Article 32. Okay, Article 32 of the Constitution of India is an article which empowers the Supreme Court to take up writ matters which expressly deals with the infringement of fundamental rights.
So let me be the devil's advocate in asking another ignorant question. So my idea from a layman's perspective is that if I have mostly all criminal cases actually begin from a lower court. Mostly, of course, there are multiple number of exceptions, but that's the general idea. A writ petition is often a case where um, you do not have any other efficacious remedies uh,
Yes, true.
except for approaching the High Court and then filing a writ petition. So, in this particular matter, you were saying that this particular gentleman had approached the Supreme Court. So was this case instituted in the Supreme Court? Like, did was
On the
the
first
Supreme Court
go.
the place of beginning?
Yes, on the first go.
So
He went
how does
ahead
that
with,
happen?
see, there is no bar. Okay, like, yes, absolutely what you have spoken about, that there has to be an alternative remedy. But
Hmm.
alternative remedy is a matter of practice, but not an absolute bar.
Correct, correct. We have judgment saying
Yes.
similar things. Right. Yep.
Okay, so it's not an absolute bar. And also, specifically, Article 32 specifically deals with those writs which the Supreme Court, which can be filed in front of the Supreme Court directly. Yes, there is a condition that it has to relate to fundamental rights only. Like, if I can, will you have the time if I read out that article altogether?
Yeah, please go ahead, please.
One second.
So we're talking about Article 32 here.
Yes.
And Article 32
So,
is one of the. Uh, Acha, I'll wait for it.
just 1 second.
Take your time,
Yes,
take your time. आराम से करेंगे.
Article 32. Yes, remedies, the title of Article 32, the first, like, the headline is remedies for enforcement of rights conferred by this part. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any rights or conferred by this part. Now, I will not go for clause 3 and 4, but in both these clauses 1 and 2, the main thing is the term rights conferred by this part. Okay, in both the clauses, it is ending with the term rights conferred by this part. Now, if anyone, like, if anyone is to look at the index of this wonderful book, then
What
you
book
will
are we
see
referring
that
to here?
the Constitution of India,
All right, so this is the Bear Act. All right, okay.
Fair Act. So if anyone is to look at the index of this wonderful book, he will realize that Article 32 is placed under Part 3. Part 3
Okay.
of the
Yeah,
Constitution of India, which
yeah.
specifically deals with fundamental rights. So fundamental rights, so it is clear that the Supreme Court can take up matters pertaining to habeas corpus. Okay, it is cleared from clause 2. Now, what are the rights in these parts? The fundamental rights, like the right to equality, right to freedom, right against exploitation, right against freedom of religion, and nothing else. If it only deals with the fundamental rights, only then can the Supreme Court take up such rights.
Okay. Okay.
So
So that's why the Supreme Court, just to clear my confusion, that's why this gentleman, this is the reason why this gentleman could directly approach the
yes,
Supreme Court as
yes, yes,
opposed to
yes.
going through the High Court first. Right.
Yes, yes,
Okay.
absolutely. So now what happened was, when the Honorable Supreme Court took up this matter, what happened? The Honorable Bench pointed out one section from the CRPC, which is Section 97,
Okay.
a section which I was completely unaware of, but is a wonderful alternate remedy for habeas corpus. Why? Because habeas corpus writs are a quite tedious, what will I say? It's a tedious process. So an alternate like Section 97 can give out better remedy in an instant. In the
Okay.
sense, I'll just read out the section: search for persons wrongfully confined. If any district magistrate, sub-divisional magistrate, or magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amounts to an offense, he may issue search warrant, and the person to whom search warrant is directed may search for the person so confined. and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before a magistrate, who shall make such order as in the circumstances of the case seems proper.
So
So
what you just
effectively,
read out in plain language is that uh, if it is found that a particular person is illegally detained, then
hmm,
a search warrant might be applied for and then granted even, and that search warrant,
yes,
the holder of the power which is granted through that search warrant is to a, in all circumstances, like in most cases, it will be probably the investigating agency, which
hmm,
is the police in plain
hmm.
and simple terms, and that investigating agency, being the police, will now do a search and then will take that detained person and bring him to court.
The function of this section is as similar as the function which the honorable high courts adopt while dealing with these habeas corpus writs.
Right.
Okay,
Mm, mm.
so effectively the only difference herein is that instead of it being a justice of the honorable high court, of any honorable high court, it is being done by a magistrate or a sub divisional magistrate.
Right. Right.
So
Mm.
in the like in our country, it is far easier to reach the doors of the lower courts than the higher courts.
Hmm. Hmm.
Okay, so in
Hmm.
that way, like effective remedy can be granted, and the honorable Supreme Court also stated that uh, this section has become a dead letter because of such writs.
Okay. Okay.
Since we are so much accustomed to filing these writs, the sections have turned out to be a redundant section because no one ever applies this.
Right. Right.
So
So
here
in this
also
in
an alternative remedy has been found.
right. So in this particular judgment, going back to the facts of the case, so we were talking about a couple who were legally married, both of whom were majors, as in had attained the age of maturity in terms
Hmm,
of marriage, legal age of marriage,
hmm,
and the in-laws of the husband was detaining the wife and was
hmm.
not letting the wife cohabit with the husband. The husband had
Yes.
now approached the Supreme Court just to sum things up, and Section 97 was effectively invoked here, if
Yes.
I'm not wrong. Right. So,
No,
so,
no,
so,
no, no.
no, no.
The thing
Okay.
is, the man who approached the court withdrew the writ, and then he undertook to follow the process of Section 97.
Oh, so
He
the
withdrew
Supreme
the
Court has now said
right.
that you have approached under habeas corpus, you're doing a habeas corpus. So
Hmm.
instead of doing a habeas corpus, you have a efficacious remedy lying under
Yes.
Section 97. So go ahead and
So yes, go ahead and
approach
approach
the
that.
court through that. All right. So, acha, acha, this is the. Acha. Do we know the status of what the 97 case? Has that been instituted yet?
That I am unaware of.
All right, all right. So basically, what Supreme Court has done through this judgment is has found or has given guidelines to finding an efficacious remedy
Yes.
to a habeas corpus.
Guidelines, I won't say
Not a guideline,
guideline,
not a
but
guideline, as in found
it
out
shed
a
light upon a
already existing.
yes, and like an efficient remedy. It shed light upon that.
So
The more
saying that
efficient.
instead of filing to the High Court and the Supreme Court, instead of filing
Yes.
habeas corpus writs, why don't you might as well approach the courts through Section 97, because that
Yes.
also gives you an alternative remedy. All right. So yeah, so those were the three things. I think the Supreme Court judgment was the positive one out of the all the other three judgments or orders, whichever the case may be. So yeah, so we had three topics to discuss on. So that's about it. But like we had said before, and this is also my question, that the mane, our head curator for the Calcuttan lawyers have still not, touched upon the CBI matter which is going on in the Calcutta High Court. And I think ABP Anando, which is the Bengali version of ABP in Calcutta, in Bengal, I think it's doing a fantastic coverage, and is Live Law and Bar and Bench. I think both of them are writing blogs on updated submissions of all the councils. Mr. Singhvi, the Solicitor General, all of them are playing fire inside court, and this has become extremely interesting for us. So how come we have not yet, touched upon it, and we are not discussing it yet? And when are we
Your
going to, like, when can our viewers, actually?
your answer lies in the statement that so many media outlets are covering it. People already know. And the second part is that yes, we will talk about this after a final order or a judgment comes out, because you will be aware, recently, I guess the matter is scheduled to be heard by a larger bench on 26th of May, if I'm not wrong. Either
Yeah, yeah.
24th, or I don't know what the date.
I think it's on
This
the
is
20. Today is the
4th,
23rd, 24th. I
3rd.
think
So
on
it will
Monday.
be heard tomorrow.
Yeah, yeah.
So let's wait for that.
So previously there was this CBI case was taken up by the division bench,
Bench.
constituted by the Chief Justice and Justice Arijit Banerjee.
Mm.
And right now, a five judge bench has been formed,
Yes.
constituting of I think all the senior judges of the Calcutta High Court,
Yes. Yes. Yes.
including
Absolutely.
Justice Harish Tandon, Justice IP Mukherjee. Yeah. So yeah. All right. So I think we will wait eagerly for your insights on that once something of the other comes out, because a lot of commentaries have come out on that particular matter, and we being both of us being from Calcutta, we are not covering something so dramatic which is happening in the Calcutta High Court. That's not fair for our viewers. It's like a plea from my side to you that let us cover that as
Yeah.
well
Obviously.
at
Obviously.
a future
Once
date.
once the case reaches its finality, yes, we can obviously talk about it.
Yeah, because I think that will make much more sense in the way, because if we are supposed to give you daily updates on a particular matter which is already being over, there has been a lot of coverage on it. A lot of media, like mainstream media houses, are covering it really well. So I don't think information per se is absent on the internet about the matter. So there's no part that we can play over here. What we can of course do, as you said, that once this case culminates and a judgment comes out, then we can take it up and discuss about.
Yes. Absolutely.
All right. So that was it from our side, from on this week's roundup of the TCL Daily, or the Calcutta Lawyers Daily. I hope you have got some kind of information which has helped you in order to understand what is happening in the country and in the legal industry. In the next week on Saturday, 10 a.m. in the morning, we will again sit with you guys, and we will again discuss what is going to happen in the coming week. And I hope that I get to see Soham again.
Anything for you. Obviously, I will be there.
All right. So yeah, so that's been it. Uh, so again, Sagni Mukherjee and Somdev Dhara signing off. So see
Bye.
you next week. Oh, all right. Oh, and one more thing. So I'll again, as I said, I'll also link everything regarding Soham in the description box. If you want to get in touch with him, you contact him through his Instagram handle. I really suggest that you start following Somdev Dhara on Instagram, because the legal content that he actually uploads, it's really fun. It's not like studying or you're going through newspapers. It's very funny. He curates a lot of things which relates to the legal industry, and also through a multiple number of pages on Instagram. So he curates all of those things together. So go ahead and give him a follow both on Instagram. You connect with him on Facebook. You can also like our page on Facebook. Just search the Calcutta Lawyers or follow the link given in the description box. Please follow us on Instagram as well, because we really need to broaden our reach as much as possible, so that we can generate a little more. Uh, I don't know what, to get more guests and more eminent people, so that we are noticed, because Harish Salve is not picking up my call. So so anyway, so
If he
just follow us
if
up.
his career goes well in the future, he won't be anyway.
So yeah, so follow us up, and we are also going to start season 2 of the Calcutta Lawyers podcast in a video format on YouTube. We will also upload all the previous episodes of the Calcutta Lawyers on YouTube over the coming week. So yeah, check out our YouTube channel as well. Link of everything discussed in this particular session will be given in the description box. So thank you so much. Thank you everyone who has
Thank you,
watched
Shah,
this.
for having me here.
Yeah. So thanks everybody. We'll see you next week.
Bye, guys.
Bye.